Welcome everyone, and thank you for joining us for today's webinar, How to Use eDiscovery in Your Law Practice, presented by Kelly Twigger. My name is Stephanie Phelan. I'm a marketing manager at MyCase, and I will be your host today. First, I'd like to give you a few tips about participating on Gotowebinar. The webinar control panel is on the right-hand side of your screen. This is where you can control audio, chat with me, and submit questions. Please use the questions pane to submit your questions at any time during the webinar. I'll be collecting those questions and saving them to ask Kelly at the end of her presentation, but please don't wait until the very end to shoot those over to me. Also, please note that these slides and the recording will be available by end of day tomorrow on the MyCase blog, and it will also be emailed to all registrants. When you close your webinar today, a very quick 6-question survey will pop up. All you have to do is answer those questions and you will be entered to win a $100 Apple gift card. You have a great chance of winning, so it's definitely worth it. If you'd like to join the conversation on Twitter, the hashtag to use is #eDiscovery. This webinar has been approved by the Wyoming State Bar and the Florida Bar for 1 hour of general CLE credit, which includes 1 ethics credit. If you are a Florida Bar member, note course number 2369R to self-report your CLE. I will also send this information out in the Gotowebinar chat pane, so don't worry. Today's webinar is hosted by MyCase, so before we jump into things, I'd like to give a quick overview. MyCase is web-based law practice management software that takes care of your daily practice requirements for calendaring, contact management, document management and templates, time and billing, client communications, custom workflows, and more in one solution at a really affordable price. MyCase is priced for solo and small firms at just $39 a month per attorney and $29 a month per paralegal or support staff. We also offer MyCase websites for our customers. The cost to set up and build your website is only $500, and then there's a $50 per month maintenance fee. We use a modern professional design built for your firm. The websites contain social media and blog integration, and best of all, a client portal which is completely integrated with your MyCase software. So now you and your customers can log into MyCase directly from your website. Next up is payments. Are you accepting payments from your clients online yet? Well, you should be, and it's easier than ever. MyCase recently announced the addition of built-in credit card payments feature to our payment service. MyCase customers can now accept online payments from clients using both credit cards and checking accounts, also known as eCheck or ACH payments, seamlessly through their MyCase account, no third-party integration required. Last but not least, we enjoy hosting educational events for professionals in the legal industry, and that's why we're all here today. So let me tell you a little bit about our presenter. Kelly Twigger is the principal of ESI Attorneys, one of the first law firms in the country dedicated to advising clients on issues in electronic discovery, open records, and FOIA, compliance and information management. Ms. Twigger splits her practice between consulting and acting as outsourced eDiscovery counsel for clients. In 2014, the Wisconsin Bar recognized Ms. Twigger as a legal innovator for her development of the eDiscovery Assistant, a web-based and mobile software eDiscovery case management tool that allows users to effectively manage the complex electronic discovery process, together with curated rules, cases, forms, and checklists. Ms. Twigger is also a co-author of Electronic Discovery and Records and Information Management, a legal resource book updated annually and published by West, and a nationally recognized speaker, writer, and go-to expert on eDiscovery and information management issues. She's a regular guest lecturer at law schools across the country and blogs esiattorneys.com/blog and at eDiscoveryAssistant/blog. Her articles have appeared online and in trade journal publications across the country. We are so pleased to have you with us today, Kelly. I'm going to pass the mic over to you now, so please go ahead and take it from here.
Great. Thank you so much, Stephanie. I appreciate it. And let's hope I'm better at talking about eDiscovery than I am at navigating the slides. So sorry about that. Let's get started right away. I wanted to tell everyone, first of all, welcome and thanks for joining us. When I do webinar presentations, I want to try and hit on the themes and the problems that the registrants and the attendees are having. And so we've tried to put together some poll questions today that will help get to some of those, but I really do want to hear in your questions, if you can send those to Stephanie, what the challenges are that you're having so that we can try and address those. And with that, I want to kind of jump in. I'm going to start here with a couple of quotes. And I'll let you read the quote. This is a quote from William Pollard. He was a very famous physicist who worked on the atom bomb. So this quote was something that he said a long time ago, 50, 60 years ago, well in advance of anything to do with electronically stored information. But it is very pertinent for what we do today because of the volumes associated with the electronic information that's created and that which we have to try and get through for our clients, even if we're only dealing with one client and one hard drive. This quote from Gordon Gekko, and I don't know if you're as old as I am, then you'll know who Gordon Gekko is. He was the protagonist in a Wall Street movie that was from the 1980s, but he was a very greedy guy who cared most about making money and said that the most valuable commodity he knows of is information. I really like this quote because as lawyers, the most valuable commodity that we have is information, because that's how we bring the successes to our clients or help them resolve things to their satisfaction. So I think that's an important consideration. Sort of tailing on those are some thoughts from me. And the reason that I give you these thoughts is because I want to try and move your thought processes today from the notion that eDiscovery is a very scary thing that you're afraid to engage in, that you have only dabbled in a little bit, to trying to embrace it and start to learn exactly how you can leverage the benefits of electronic information for your clients. Because I can tell you firsthand over the work that I've been doing solely on electronic discovery for the past 9 years, that there are tremendous benefits to be had once you think about what it is that you're looking for. And you don't need to know everything. You don't need to know everything that's happening in electronic discovery, every type of technology, the scope of the universe. You need to know what's relevant for you and your practice. So kind of in that way of thinking, the goals that I came up with for today's event was to start you thinking about ESI and to make you understand that you really know more than you think you do. We want to talk about how eDiscovery fits into your practice, the ways in which you can examine your practice and come up with processes, procedures, tools, whatever you need to be able to make eDiscovery work for your firm. Help you understand what the obligations are that you have to your clients based on existing ethics opinions and laws, and try and give you some tips for putting together a cost-effective approach for eDiscovery that meets the needs of your firm or your clients. Okay, so with that being said, we're going to jump into poll question number 1. So the first question is, what is your current approach to eDiscovery? And the answers are, oh my goodness, that wasn't good. Hold on. I hate when it goes into under overdrive. There we go. Answers are A, it's covered. We have processes and protocols to conduct and manage eDiscovery in-house, and our attorneys follow them. B, not so much. We have some information, but know that we need more. Or C, clueless. Why do you think I'm on this webinar?
Perfect. So if everyone can please go ahead and select your answers there. I'll give you another few seconds and then I'll close the polls. All right, going to close. And our results. Okay, so what is your current approach to eDiscovery? 11% said it's covered. We have these processes to manage eDiscovery in-house. 39% said not so much. We have some information, but we need to know more. And then our majority, so 50%, said clueless. Why do you think I'm on this webinar? Is that any surprise to you, Kelly? No. So 11% said it's covered. We have the processes to manage. 39% said not so much. We have some information, but we need to know more. And 50% said clueless. So those are our answers. And if you can bring your slides back up again.
Okay, my slides are back up, so let's try it again.
Okay.
Can you see the slides now?
No, it could take a second. I don't see them.
Thanks, everyone, for your patience and technical difficulties.
Yes, thank you.
Where these things never happen until you're on a webinar.
Exactly.
Okay, so 11%, 39%, and 50%, you said, right, Stephanie?
Yes, that's right.
Okay, so let's kind of dial back. So we've got about 89% of you who are still kind of, we need to figure out exactly what we're doing. Some of us are more on the we need to get started. I want you to go back to the notion that I kind of started at the beginning, which is to think about ESI. Each of you in your own lives deal with ESI on a regular basis. So you're constantly using your phone, you're constantly on social media, you might be using Facebook, you're getting voicemails in your inbox from your phone systems, you're getting emails, you're getting instant messages, you look at videos that people send you or post on Facebook, you look at Instagram and pictures. You have GPS information that's tracking that's in your phone. You have audio files. There are all these kinds of information that are out there that we can now use to assist our clients in getting the information that they need to be able to understand the facts of litigation and be able to resolve it faster. And so I want you to start acknowledging taking what you use in your everyday life and translating it to thinking about it in your litigation, in your law practice. The other big piece to be thinking about right now with regard to sources of ESI is what's called the Internet of Things. Some of you may know a lot about the Internet of Things. Some of you may not understand it at all. All it really means is that now we're starting to add devices that capture information. We're connecting them to the Internet, and we're starting to spread the information that we have about ourselves and about the heating in our house or about what our notifications are from our phone on our Apple Watch, or we're putting out a Wi-Fi signal from our car that other people can hook into. And so the Internet of Things is expanding this notion of there being ESI out there for us to find and leverage for our clients. And the question becomes for you is, what is it that you need to be thinking about for your clients? In a particular case that comes to your desk, what can you sit back and say, hey, these are some unique sources of ESI that I know I'm going to have? I mean, primarily we have a lot of email, we deal with a lot of PowerPoints, a lot of documents in more corporate litigation. But in unique circumstances, in a lot of plaintiffs' cases that we work on, in consumer class actions, in other things, you're going to deal with much more complex information that you need to be thinking about. How is this organization tracking the information that I really need to win my case? And we're going to talk about that a little bit more in a minute. These are some of the myths that I hear a lot, and every time I say the word myths.
Kelly, we still can't see your slides. Would you like me to use my slides? Do you want to try and show your screen again?
I guess so. If that's not working, why don't you go ahead and show the slides? I'm on the ESI myths slide.
Okay, got it. It'll be just a moment. Oh, sorry, one moment. All right. Sorry, everyone, for this. Gotowebinar has decided to poop out on us a little bit. All right, here it goes. And I'm just going to leave that in slide sorter mode for now. Do you see my screen?
I don't know, but I appear to be completely off of the internet now. That's awesome.
We can hear you.
Okay.
Okay. And is everyone able to see my screen? All right, I'm on the ESI myths.
Okay. So these are a number of the myths that I hear on a regular basis about why lawyers have not decided to get on the bandwagon as it relates to electronic discovery. And most of the time I hear from a lot of litigation support folks that they're very frustrated because they try to get their lawyers to leverage the technology, and they're hearing from them that they really want all of the documents printed out and put in as PDFs and put in a binder for them to be able to review. And in fact, I'm completely with you. I had that exact request from one of my outside counsel today, and my internal team all cringed with the same face that you use. So we need to get past these myths, and here's a lot of what I will tell you. If you can switch to the next slide, Stephanie, next slide, is that at this point, as it pertains to these ESI myths, you need to get over it and get on board. The complexity of electronic discovery is only going to continue to grow, and while we still deal in our practice with historical documents that are in paper and still in off-site storage, the notion that paper documents are going to be around for very much longer is not a viable one. So we really need to get on board with dealing with electronic discovery, but we need to inch people in that direction. So we're going to try and talk about ways to do that today as well. If you can go to the next question then, please, Stephanie. So poll question 2 is, what types of matters are you handling? And your choices there are A, general commercial matters or intellectual property, B, employment matters, C, products liability or personal injury matters, D is divorce or family matters, or other.
Okay, great. So the poll is up and running. If everyone can please go ahead and cast your vote. All right, and it looks like majority has voted, and I'll go ahead and close the poll.
What do our results look like?
Okay, and our results are in. So what types of matters are you handling? 24% said general commercial matters, IP. 6% said employment matters. 13% products liability or personal injury. 16% divorce or family matters, and we have a lot of others, so 41% for other. What 41%. Are those? Yeah, 41%
okay,
for
so
others.
If you have on your sort of panel there, as it pertains to others, give us some idea of, what those others are. Just kind of type them in there, and in a minute I'll ask Stephanie to tell me about them a little bit. In the meantime, if you could switch to the next slide, Stephanie. So kind of going back to our guide, when we were talking about thinking about ESI, one of the things that I would like you to focus on today is to really change your approach to discovery. You can go to the next slide.
Mm-hmm.
The default approach for lawyers, and this has always been my default, or had been my default until I started engaging with ESI in 2004, is to kind of get a case and say, okay, we need all of the communications between these people, we need this information, we need that information, we need the whole database of claims, we need all of the email communications for this 5-year period between this organization and that organization. That thought process now, that sending broad discovery requests, just ends you up with a huge amount of information. It has 3 real consequences. First, it takes an eternity for you to be able to get that information because you've asked for such a broad range of information. Second, it's going to cost you a fortune to look through it, and it's going to have cost the party a fortune to produce it. And third, it's going to be really difficult to find what you're looking for and to spend any time thinking about the documents that you have because you're going to spend most of your time filtering through it. Can you move to the next one?
Yep.
So, why doesn't that approach work with ESI? Well, it doesn't work because you're not having any conversations with counsel, which is what we refer to as the meet and confer. And at that meet and confer, that's where you would gain an understanding of what information may or may not exist. Here's an example. At a meet and confer where I come as plaintiff's counsel and I say, the relationship between these 2 entities has gone back for 15 years. I want all of the information that's available for those 15 years. And on the other side, I say, or opposing counsel says to me, hey, Kelly, I hear you. We don't have information back for 15 years. here are the 10 key people, here's the amount of information that's available from a date range perspective, but let's focus on what the actual issues are in the litigation. This is an isolated incident that happened in the course of this relationship, and we've done some looking at our clients' data. We feel like the appropriate time frame is really a 2 to 3 year time frame right around here. So what we'd like to do is agree to that with you. We'll prepare that information, and then if you look at that and say we need something broader, either from an individual custodian or from all of the custodians, then we'll explore that possibility. But we'd like to start with a narrower window. That's an example of how a meet and confer conversation can really help narrow the scope, get you information faster, make it less expensive for everybody concerned, allow you to really focus on the issues in the case. Not understanding what information may or may not exist is, again, what leads to those three things, just the higher costs and more digging through unrelated information. So, you know, default approach has higher costs with low reward. Instead, let's look at a different approach. I'm going to encourage you to change your approach for discovery and dealing with ESI to this approach. Did you move to the next one, Stephanie? Do we have up the change your approach slide?
Yes, that's up.
Okay. So instead of asking for a large, broad discovery pool, I want you to think about the types, sources, and range of data that's available and work to narrow what you ask for. I'm not suggesting that you send out very narrowly tailored requests for production or even interrogatories from the get-go, but what I am suggesting you do is send a lawyer to the other side and say, here are the things that I'd like to sit down and discuss with you. If you need a little bit of push to be able to get the other side to do that, you can send a broadly drafted set of requests for production and say, here's a broad set of requests for production. We'd really like instead to sit down and come up with a more tailored approach to discovery for this case. Please let us know when you can do that. Otherwise, we'll just send you these broad requests. That often has a lot of effect in bringing people to the table. And then once you narrow that, then you want to use tools and thoughtful searching techniques, a lot of which you learn through talking to your custodians to be able to get the info that you want quickly. One of the mistakes that I see a lot of folks make is farming out the talking to custodians to lit support folks, or in talking or understanding the environment that they should try and get information from before you've talked to the business people and understood what kinds of information they have. Start with the business people, understand what kind of information they have, and ask them what are the terms that they use to refer to the data. Then verify those before you provide information. Okay, let's move to the next one. Okay, so that's thinking about eDiscovery. Stephanie, did you get any input on the other kinds of cases that folks were seeing?
Oh yes, we got a lot. I can read some of those to you. So we got class actions, environmental, we got road, real estate, tax abatements, bankruptcy, personal injury, land use and zoning. We got a lot of people that said criminal defense, workers' comp, real estate, and estate planning. Yeah, there's a lot.
Okay. All right, those are all really good. So one of the things that I would make sure that everybody on the call understands is that the principles of eDiscovery are the same for every type of case. It's your sources of ESI, how you handle the information, and some of your complexities. There are more complexities in dealing with criminal law because you have a lot of authentication questions, a lot of chain of custody questions with regard to evidence. So there are more complexities there that are separate from civil litigation. But with regard to class actions and a number of the other pieces that you raised, and we're going to get to size of case later, it really is about sitting down and thinking about your case from your client's perspective and from the other side's perspective. The question that I usually ask is, what does outside counsel want to say in their closing statement? If you're standing before a jury of 12 people having just tried this case, what are the facts that you want to use in your closing statement? And work backwards from there. So in the old version of Discovery, we use sort of a funnel approach, this top-down, grab everything and then funnel it down to the bottom. There's so much information now with ESI that I want you to think differently about it. I want you to take a more targeted approach so that the amount of information you're putting into the top of the funnel is much narrower than it otherwise would be. In talking about this section for your practice, and I'll try to address some of those other practice areas that you meant as we go along. Because in a large way we kind of positioned this webinar for small firms and solo practitioners, I think it's really important to note that your eDiscovery practice, whatever that may be, needs to fit what meets your client's needs. And so you need to adjust your practice, improve your processes, up the kinds of tools that you use as your practice becomes more complex and you're dealing with more data or more sophisticated kinds of data. If you have smaller cases where you're dealing with, you know, a $10,000 or $100,000 case, and you need to not spend a lot of money, you need to have tools in place and processes in place to understand how you're going to do that so you don't spin your wheels. Let's move to the next slide.
Okay.
The next slide related to your practice is another poll question. What is your biggest challenge in eDiscovery?
Great.
So, and the answers there are, I do not understand technology. I do not know what tools to use. My clients do not want to talk about it. Hello, I'm on this webinar. It's all a challenge.
Okay, great. So please go ahead and cast your votes. It looks like 50% of the people have voted, so please get your vote in, and I'll close the polls. And our results are in. So 5%, only 5% said I do not understand technology. 50%, so our majority, say I do not know what tools to use. 15%, my clients just don't want to talk about it. And then 31%, hello, I'm on this webinar, it's all a challenge. So I'll hide those results.
All right. So with regard to the tools, we'll talk very little bit about that today. That is a separate webinar in and of itself, and to the extent you're looking for individual recommendations on tools, I'll give you a way that you can reach out for me to be able to discuss that with you, but that's a whole separate topic for another webinar, but something that we can talk about a little bit. Let's move to the next one.
Yep.
Okay, so I'm going to pick up the pace here a little bit because due to technical difficulties, I lost a few minutes. eDiscovery for your practice, again, is focusing on exactly what it is that you need. What are your needs? When you sit down to look at electronic discovery, you need to say, what is it that we want to have in place? Do you want to have a process, a legal hold process in place that all the firms, all the lawyers at your firm can use to be able to send out legal hold notices? Do you have an ability to manage that internally? What do you want that to look like? How many matters are you talking about that you're dealing with on an annual basis? What are the size of those matters? How much are the annual billings for each of those matters? How much data are you collecting from your individual clients? Are you keeping any metrics about the cost of dealing with electronic discovery per custodian? Can you give me a number that I would be able to use as outside counsel to make a budgetary decision? If we have a new case and we guesstimate there are going to be 20 custodians, here's our number, so we guesstimate this is going to be the cost of electronic discovery for that case. That's a huge added benefit to your clients, and it's one that we use to be able to develop our client relationships into further business. Internal resources that you already have. What can you leverage? Who can you leverage and what can you leverage? When you're looking around at your staff, when you're looking around at the tools that you already have in place, what can you leverage that you're not already using? These are some questions to ask when you sit down with whoever your internal group is that's going to focus on dealing with electronic discovery. What kinds of processes can you put in place to get ready? These are legal holds. These are how do we request data? What kind of format do we want data in? What works best for the tools that we have? What are the client needs that you're supporting go hand in hand with that? Are you dealing with class actions, or are you dealing with a smaller, or maybe it's a very large estate litigation? How many parties are involved? The number of parties that are involved can dramatically increase the complexity of discovery and the need for managing things effectively. Budgeting. If you're thinking about bringing tools into your firm to deal with electronic discovery, you ought to be able to calculate the outright cost of those versus the ROI that's going to be associated with them. If you're using outside vendors to be able to handle data, then you know what those costs are. You ought to be able to get metrics to be able to break those down by custodian. And so you ought to be able to budget out, if you know the information in the first bullet point there, the number of matters, the size, et cetera, you ought to be able to budget out how quickly you'd reach an ROI that would be better than the vendors. But don't forget to include the cost of hardware and the cost of salaries for those employees. In terms of what works for a particular practice, there is no one-size-fits-all and no easy button. It is something that you will have to sit down and figure out. If you want to work with someone to figure that out, you need to have a base level of understanding of what it is that you're talking about. Could you move to the next slide, please, Stephanie?
Yep.
So, and that kind of goes in this eDiscovery for your practice. What kinds of evidence are you looking for to win your case? Where does that evidence live? Again, to the budget issues. And these are some of the things that you want to think about in trying to learn everything you need to be able to put together appropriate eDiscovery for your practice. What do you want to learn from the conversations you're going to have with opposing counsel? We gave an example of that one earlier with the meet and confer and narrowing a date range. There are pretty easy ways to filter the amount of data that you're going to end up using, and things that will save a ton of money and again get you to the information you want to use faster. So when you're sitting down and thinking about how to put together eDiscovery for your practice, you need to think about, what does that look like? What is it that your practice actually looks like in terms of cases, the kinds of evidence that you're looking for, where it lives, and then physically what you really need from an outside provider or that you need to supplement within your firm. Do you just need somebody who can go out and image hard drives? Do you need somebody who knows how to engage in remote collection so you can do a targeted collection? Like, the way that we do remote collection is we set up a WebEx with a custodian, usually when our internet is working, and we then go on and target the specific files that the custodian needs collected, as opposed to gathering, I think last week we looked at a 185 gig file that was sitting on a shared network for a client, and we didn't want to collect the whole 185. So instead we went to each individual custodian and said, point us to the files of this very large 185 gig file, that the subfiles that you use, and what are the ones that are relevant, and we collected just those. So in doing that, we collected about 20 gigs of data instead of 185. If you think about just the difference of maybe processing that information at a cost of, let's say if you were using Relativity, about $200 a gig, 200 times 185 instead of 200 times 20. That's a pretty big difference. Okay, let's move to the next slide.
10.
So this part of the presentation, what we are going to move to, and I'm going to kind of roll through some of these things quickly because I get a sense from the question answers that we do have about half of the folks who are not really sure exactly what they need to be engaging in. There are some ethical rules that have come out in the last year and a half that really have shed some light on what your obligations are with regard to electronic discovery for clients. The ABA model rule on competency, that didn't change, but if you'll move to the next slide, what did change is this new comment 8 that came out to the competency rule. It basically said, lawyers need to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. Now that is a very broad statement, which many of those of us who practice in eDiscovery were unhappy that there was not a little bit more specificity there to encourage lawyers to get on board with the technology and understand what it is that they need to know. Go to the next slide, if you would, please, Stephanie. Okay. The next big piece that came out in 2015 was a formal opinion from the California State Bar. And some of you may be familiar with this. If you're not, this is the one opinion across the country dealing with eDiscovery ethics obligations that I would recommend that you sit down tonight and read. You can Google California State Bar eDiscovery opinion and come up with the link. You're welcome for you to send me an email, and I'll send you a copy of the document. But I would suggest you read it. It's about a 10-page document. It is all chock full of very good information, and it's very helpful to you understanding what your obligations are as an attorney in dealing with electronic discovery. So let's go to the next slide.
Okay.
That same opinion says that an attorney who lacks the required competence for eDiscovery issues in a matter has 3 options. 1, go out and learn what you need to. 2, consult with somebody else who can help you make sure you know what you need to. Or 3, decline the representation. We all know that number 3 is never really what we want to do, so 1 or 2 seem to be the best options. Let's move to the next slide.
Okay.
This California opinion sets out 9 specific steps, things that lawyers need to be able to do in order to be considered competent under the California rules, California ethics rules, at handling electronic discovery. And this is quite a list. This is going to be a list that some of you are going to think, oh my gosh, I don't know how to do any of these things. And these are essentially the steps of walking through the electronic discovery process. Assessing eDiscovery needs and issues, we've talked about that. Implementing ESI preservation procedures, putting a legal hold in place, identifying the information at the client that needs to be kept, and advising the client on making sure that information is either captured or collected. Analyzing and understanding a client's systems, identifying relevant custodians with the ESI, performing appropriate searches. Let's move to the next one.
Okay.
Number 6 is collecting information, advising the client on all available options. And 8 and 9 are really important, 8 in particular. 8 is the engaging in competent and meaningful meet and confer with opposing counsel. We've talked again about the benefits of that meet and confer. I can tell you that 9 out of 10 of the meet and confer sessions that I participate in, and I do a couple of them a week, are I get a lawyer on the other side who comes to me in a much more aggressive, hostile sort of capacity who wants to say, I don't want to provide any information about my client's information. And as I kind of dig deeper, I learn that that lawyer really doesn't know anything about it because he doesn't know what questions to ask his client, or he hasn't asked his client any questions. All of the lawyers and judges and other folks who get together on a regular basis and engage in thoughtful discussion about electronic discovery, we really want everyone to try and step away from this super adversarial nature as it pertains to electronic discovery, so that we can all get the information that's needed and be able to move forward. I know that is likely a very big pipe dream, and you can all laugh amongst yourselves at your desks, but I'll tell you, it saves an absolute ton of money, and it really does move the process forward, and it's best for everyone, because we all know that the cost of litigation ultimately ends up in creating a higher cost of every service and product that we have in this country. So this is a small step that can be a huge impact going forward on the legal system for you to engage in that meaningful meet and confer. How are you going to do that? Well, you're going to have to do some learning. Let's go to the next one.
Okay.
I'm going to skip over this one just for time purposes today, but these are some additional ethical obligations that California opinion lays out, that in addition to being able to do those 9 things, you have to have all the appropriate things in place to take care of the data as well. Let's move to the next one.
Yep.
Okay, so cost-effective approaches, how to plan cost-effective approaches to plan for your needs and your clients. And one of the things we'll talk about in here is tools, since we had such a large percentage of the population who needed to understand that. Let's move to the next poll question.
Okay.
Poll question number 4, what is the average value of the matters that you are handling? And those answers can be A, less than $10,000, B, between $10,000 and $100,000, C, $100,000 to $500,000, D, $500,000 to $1 million, or E, more than $1 million regularly.
Okay, great. So if everyone can please select your answer, and I'm going to close the polls. All right, and our results. What is the average value of matters? We said 20% said less than 10K, 41%, so that's our majority, said between 10,000 and 100,000. 22% said 100,000 to 500,000, 8% 500,000 to $1 million, and 9% more than $1 million regularly.
Okay, the majority of our folks are between A and B. So if you've got matters that are less than $100,000, then your budget for electronic discovery needs to say somewhere around the, well, as low as possible, but I'm going to say between the $5,000 to $20,000 range for the $100,000 matters, and as low as $1,000 to a couple $1,000 for the much smaller matters down to the 10K. And you may even want less than that. You may even agree not to engage in some sort of discovery. There are individual ways to deal with matters that are of very low values that might have a lot of information that you have to sift through that could increase your cost. A lot of that can be doing very targeted collection, and some of it is mutual agreement between the parties. So I'm going to give you all of this information rather than me reviewing it. I want to engage in an order whereby we say that anything that's privileged gets automatically returned to me, no questions asked. And we're going to agree that both parties have said that based on cost, we're not going to review everything that's here, or we're going to review subsets of information. That may scare you, but those are some sample approaches of how to be able to deal with very low-cost matters. The higher the cost matters you get into, typically the more information you're looking at, and that's where you start engaging with dealing with remote collection and dealing with review tools and trying to use strategies, human strategies. I mean, there are complex tools that you can use, technologies that can be used, but I'm a very big proponent of the human thought process as it relates to litigation strategy and eDiscovery. A lot of what I see is that we have pushed dealing with data down to lit support folks, and the lawyers are losing track of the strategic advantages that are involved in understanding and knowing the data. And so I would really encourage you as lawyers to get down in the trenches and be able to see the data and work with your lit support folks on what it is that they're seeing. Let's move to the next one.
Okay.
Okay, so how do we engage with cost-effective approaches? For those of you who are on the phone who are in the hello, I'm on this webinar call, everything is a challenge. The places where I want you to start are to sit down and think about the matters that you have in your firm or that you're dealing with and what the current approach is that you're taking relative to eDiscovery, and literally write it down as steps. 1, 2, 3, 4, 5. Write them down as bullet points if you want. Who's responsible for them? What's happening good? What's happening bad? What you're nervous about, what you're afraid of. You're afraid that privileged information is getting produced. You're afraid the client thinks you're spending too much money. You don't like that you're being told at 6 o'clock at night that something has to happen by the next day. Whatever those things are, you need to write them down, and those need to be the basis of how you start figuring out what your approach is to electronic discovery. What is it that you don't have from a tool perspective that you need to be able to do? Do you need to be able to image a hard drive? Do you need to be able to load documents in a review platform that isn't 10 years old and keeps crashing on you and only takes a certain form of data? You know, what do you need to identify some new options for the firm? And if so, what is the firm's budget? Who are the folks that are with the firm that are going to be able to provide that information? So get that plan in place, because the most cost-effective approach is having a plan in place to deal with the early onset issues in electronic discovery when a matter comes up. So I've been in practice now for 20 years, and when I started, what would happen is I would come into my office and there would be a file folder on my desk that was about 10 inches thick, and it would have a note on it that would say, "Call me," and some partner's scribbled name at the bottom of it. And that would be how I got new cases. And when that's what happens, you know, you tend to dive in slowly, and you tend to start talking to the client once you feel like you have a grasp of the issues, and everything happens much slower. Electronic discovery means that that can't happen at that pace anymore. It means that from the instant that you know that there's a case, it means your client has probably known that there would be a case for at least 6 weeks, if not longer. And that means that their duty to preserve information attached at the time that they became aware that litigation was either imminent or reasonably anticipated. And so you need to have a plan in place for how you're going to deal with that stuff. Who is the person at the client that you're supposed to call? What is their legal hold process of management? If they don't do it, how are you going to manage it for them internally? How are you going to identify custodians? How are you going to collect information? What are you going to use to preserve? How are you going to determine scope? Who are the folks you're going to work with? If you don't have those kinds of things in place with existing clients, then this is the approach that I take. I take either the general counsel or a lawyer, any lawyer in the legal department that I work with on a regular basis and have a good relationship, and I take them out to lunch. And I say, here's the thing. We've had 3 matters in the last X amount of time, and these 3 things have really fallen through the cracks or have really cost you a lot more money than they should have because of the way that they've been handled. And what I'd like to do instead is to spend a little bit of time getting a process in place so that when this comes up again, we can handle it on a much more cost-effective basis. It will cost us about X to get this in place. It has cost Y 3 different times on these last 3 litigations. And numbers are what in-house counsel understand. So giving them, here's what the actual ROI is to us doing this work is important. Lawyers don't do that well, and it's something that we need to change, and electronic discovery is a perfect venue to institute that change. If you need third-party assistance, and going back to the cost-effective approaches, if you need third-party assistance, you need to get that in place now, not when the litigation happens. Tools and resources that you want to have in the firm to leverage, you need to get those in place now, and you need to test them, and you need to play with sample data. You pull some own data from your own firm internal systems and put it in there as a case and play with it. See what the bugs are. If you're going to use external tools, you're going to want to play with those as well. You don't want to learn as you go on your client's data. And you need to learn about the ESI that's involved in your cases. When you do a run and you figure out what you need to keep for privilege and what kind of filters you can run, set up standard filters to be able to leverage for all your clients. That's work that can be done during downtime. So there are a lot of ways that you can really put together a cost-effective approach, but it means stepping back from the normal crazy fire drill that is litigation, and it means documenting some of the practices and procedures that you're doing. Every time we cull a bit of information from a client, so for instance, yesterday we received data that I think came out to about 130,000 documents for a custodian, and using a whole bunch of different culling filters, so third-party domains, the date range of the time period that's necessary for production, knowing certain domains of communication because of information that we ask custodians. We called that 130,000 documents down to almost 3,000 that could then be reviewed. And then with a first pass review, we'll cull those down even further. So that's a huge cost savings of not having to process and deal with all of that information. So those are some really key ways in which I hope that you'll start to engage with electronic discovery. If you want to move to the next slide, Stephanie.
Okay.
I'm just going to give you a quick, one of the things that we do at ESI Attorneys is to help folks really just get on a path with their case. So we offer this By the Glass service, which is an opportunity for you to essentially sign up and prepay on a flat rate. I believe it's $400 for an hour-long session where we sit down and talk about the case and give you advice on whatever it is that you need, how to structure your strategy, how to pull together your list of custodians, what kind of sources of information we think might be relevant for you to look at, whatever it may be. And then we usually send a follow-up email with some advice, whether that's recommendations on tools that you want to be able to use. And a lot of people who sign up for this service with us call to discuss tools because we're always looking at tools in the marketplace, and we use a variety of tools here within our firm. So if that's something that's helpful, you're more than welcome to reach out to that. You can sign up by going onto our website, and for some reason I didn't put a link there, but if you go on to esiattorneys.com, there is a link to By the Glass Consulting that you can sign up. I think we're also going to put a question in the survey about it. If you want to flip to the next slide, and I'll wrap up here in just a minute, Stephanie. Mm-hmm. So outsourcing in education, how do you go and find more information? Here's what I'll tell you. I think the question is that you need to sit down with your plan and say, what is it that I really need to know? Unless you're looking for CLE credit, which if you are, by all means, go to whatever presentation, floats your boat. But if you're really looking for information that is going to be specific for you, you're going to have to filter through a lot of those presentations to go and get it. I would encourage you to find a non-affiliated consultant or attorney to work with who you can trust and who you feel has good advice to help you identify whatever the issues are that you're trying to work through, and to get some solutions to those. Along that way of thinking, one of the things that we created, if you can switch to the next slide, Stephanie, is a tool called eDiscovery Assistant. This has been described as the Westlaw of eDiscovery. So this database, this now a SaaS-based tool, which is brand new, rolled out as of about May. And some of the information is included here, and I want to make sure we have some time for questions, so I'm not going to cover it too much. But eDiscovery Assistant is a virtual consultant, essentially. It has rules, case law, checklists, forms that you can use within your practice, and we're constantly updating that information. And it has just been rolled out for the internet. So I think within the survey, there's a question about whether or not you'd like to get a free month subscription to eDiscovery Assistant. So if you'll answer the survey questions, then we'll be able to hook you up with that. If you want to jump to the next slide, and then you can just kind of skip over that one. That's some screenshots of eDiscovery Assistant.
Okay.
And then let's move to the questions portion. Do you have some questions, Stephanie?
Yes, we have lots of great questions. But thank you so much for those great tips, Kelly. And for those of you who have to leave us now, please take note of 3 things. When you close your webinar today, that 6-question survey that Kelly just mentioned will pop up. So all it takes is answering those questions, and you'll be entered to win a $100 Apple gift card, so it's definitely worth it. And I did chat the CLE course number, but if you're the Florida Bar member and you need to know your CLE course number, it is 2369R, so you can self-report that. And lastly, you'll receive an email tomorrow with a link to our blog, the MyCase blog, where you'll find these slides, the webinar recording, and the Apple gift card winner. So we do have a lot of questions. We won't have time for all of them today, but there were a few that had kind of a theme to them. So the first question would be, how do I know that opposing counsel isn't misleading me about what information he or she has at the meet and greet?
Well, the short answer is you don't. And so if you need to take steps to be able to obviate that, you can take a 30B6 deposition of the appropriate witness to answer those questions. If you go on my esiattorneys.com blog and search, you'll find a blog post, or if you send me an email, I'll send it to you. I don't typically recommend you taking 30B6 depositions of IT people because I don't find them to be very helpful, but I do routinely take 30B6 depositions of the business people so that I can understand how much information is available, because I have had multiple occasions where opposing counsel does misrepresent what's available.
Yes, I bet it happens. Okay, if we're ready for the next question, how do you protect your client from overly broad requests for their electronic data?
There's a new rule. We didn't cover the amendments to the Federal Rules of Civil Procedure today, but Stephanie and I were talking about some additional webinars, follow-ups that may be valuable. So if you think that's valuable, please let us know. There's a concept in the Federal Rules of Civil Procedure called proportionality, and the new amendments that became effective on December 1st of 2015 brought that concept of proportionality to the forefront. And that notion says that you should not be, the value of the information that is being sought should not be, it shouldn't be out of proportion with the cost and burden to be able to produce it. So you need to argue, you need to look at proportionality cases, and you need to be able to make an argument that the overbroad requests are not proportional. And if you want to be able to do that effectively, if you log on to eDiscovery Assistant, everybody can log on to eDiscovery Assistant and set up a free trial for 7 days. if you go on to eDiscovery Assistant, within the case law section, one of the things that we did was create an information architecture with tagging of eDiscovery issues. You can click on the proportionality tag within the eDiscovery Assistant, add that tag in the case law, and you'll find all the proportionality cases from across the country, and you can sort them by your jurisdiction. But proportionality is the answer to your question.
Great. Next question. Is there a certain technology architecture more appropriate for eDiscovery? How has cloud architecture influenced eDiscovery?
Cloud architecture has made it so much easier for anybody to upload data from their desk and be reviewing information in an hour or two, depending on the amount of information you're looking at. The thing that's different about cloud than standalone programs is that the features and functionality, literally the complexity of the tools may not necessarily be as available in cloud-based tools, and I'm thinking specifically about review platforms. But the long and short of it is that the availability of the cloud means that eDiscovery as a process can be done so much more efficiently and effectively. I will tell you that in the last 7 days, we have, in my firm, collected data from 22 custodians, all via remote collection, sitting at our desks, where the custodians were all over the country. And that information, in turn, was uploaded to a cloud, a data center. So it does exist, but it's a data center. It's not ours, so we call it the cloud. And then that information is then input into a review tool, all cloud-based. Most of what we do in our practice is all virtual, but it is all behind appropriate security walls.
Excellent. Okay, another great question. You mentioned previously the legal hold process. What is that?
The legal hold process is the process by which you inform individual custodians at your client that they have an obligation to retain information for a matter. And so, for example, if ABC is suing DEF over the sale of widgets and non-performance of contract, then you would send a legal hold both to your client internally to tell those custodians, say there were 10 or 15 people that were involved there, you'd send a written notice generally to those 15 people, identifying what the documents are that they should keep and giving them kind of an overview of the matter and explaining what their obligations are with regard to preservation. The management of that process, who responds to that legal hold, how they respond, knowing that they got it, any follow-ups that will be done, is a larger part of the legal hold process.
Got it. Okay, so looks like we have time for one last question, Kelly, and that is, I receive ESI in Discovery and don't know what to do with it. How do I figure that out?
Well, that's a broad question. So when you receive ESI, the question is, what did you receive? So if you have a CD, if you have a drive, if you have something, you need to plug it in and see exactly what it is that you've gotten. Generally speaking, we receive ESI with some sort of cover letter that tells us what the file types are that we've received, what the data actually is. So if you didn't receive that information, you need to call the counsel who sent it to you and ask for it. But generally speaking, the file types of information that you've received will tell you what you need to do with it. If it's a whole bunch of PDFs, and it's a low-cost matter where you just want to be able to look at them on a one-off basis, you could open up Adobe Pro and be able to look at those PDFs. There are settings issues as to whether you might make some changes to that data. I always recommend that when you get ESI in-house, you automatically make a copy, a backup of that data in the event that any actions that you take have a tendency to corrupt that data. So the answer is, long and short, that it depends on the type of data that you get and the quantity of data that you get and what it is that you ultimately want to do with it. So if you want to have the ability of 5 lawyers to review that information, then it needs to be in a review platform that those 5 lawyers have access to. That can be a cloud-based tool, or it can be an in-firm-based tool, whichever is what makes the most sense for your organization.
Got it. Okay. Well, Kelly, thank you so much for answering those questions, and thanks to everyone who sent them, and thanks for joining us today. That's a wrap. So thanks everyone for joining us, and we'll see you again next month.
Great. Thank you.
Thanks all. Bye-bye.